Right, this is cause number 1830854, and sir, you're Juan Sanchez?
Yes.
And so we're here today on a motion to compel.
It starts with motion to compel. Legal code for they're holding back evidence, and we want it now. But right out of the gate, the judge spots a problem. The filing isn't clean. And in court, one small mistake can flip the entire case. Get ready. This one's about to get technical.
Before we get into a whole lot, I've done a lot of my own research and looking at all of this. And a couple of things. One, I don't believe the subpoena ducis tecum was the proper way to try to get the information. Ducis tecum is an order to get somebody to bring something to a set hearing. So we didn't have a set hearing, and they weren't ordered to give it to at a set time for a hearing. So under the rules that have to do with subpoena ducis tecum, I don't know that that was the proper way. I do think you're entitled to some of that information as a defense attorney. If we're going to base decisions on, if I'm going to base decisions on things that probation have in their file and that they're just going to tell us, I do believe that you are entitled to some of that information. I think
Ever heard of a subpoena ducis tecum? Fancy Latin for bring the documents to court. Simple enough, right? Not quite, without a scheduled hearing. That request might be meaningless. In law, the secret isn't just what you file, it's how and when you do it.
To make that request through the district attorney's office for discovery, and then for you, Mr. Nichols, to make those requests, and then I would approve you guys giving whatever records are requested within reason. If you have, I don't know what would necessarily be any type of work product that would not be discoverable, but if you think that there's something that is particularly not discoverable, let Mr. Nichols know that, Mr. Nichols let me know that, then we could worry about maybe a motion to compel and whether or not I think those things are or are not. But lab results, of testing, money owed, all of those types of things, I think are probably discoverable and something that Mr. Franklin needs. I just don't think this was the...
I agree, Judge. Any of the things that pertain to, well, I do think it's discoverable. In this case, it's all allegations on the motion are based on arrest out of county. And so his attendance record and all that, I don't know why we're subpoenaing the entire probation file when it's not even part of the allegations for the motion.
May I respond, Your Honor?
Well, let him finish, yes.
He did subpoena Wharton County records, so a representative from probation down there came in today for this hearing. I have no problem with getting him all that stuff. A lot of it's not in my possession. The out-of-county offense reports and things like that, I don't have yet. I would have them if we move towards a hearing where I prove up those allegations, and they, of course, will be provided beforehand. And again, I don't think he's not entitled to have all that stuff. So
sure.
I kind of agree with
So,
the subpoena directly to those agencies was the proper way to do this. And Mr. Franklin did make just a standard discovery request at the onset of his involvement, which was early May. I don't have anything really responsive to that at this point.
Okay. So obviously, if it's based on a new offense out of another county, that's something you'll need to work towards getting and get that to Mr. Franklin. And so that needs to take place as quickly as possible. Let me look at the motion itself. Because I don't know, I guess, Mr. Franklin, if there's not an allegation in the motion to revoke with regard to certain administrative violations, and there isn't an allegation, then why would you, what is your argument that would be?
Then comes the heart of the defense. My client's been on probation for almost 6 years. He's trying. The question hangs heavy. Do you punish a new mistake or recognize years of progress? Justice isn't always black and white. If you were the judge, how would you rule?
Your Honor, my client is wanting to stay on probation, and the court may take into consideration his performance while on probation, including his payments, his report, and everything else. So as part of determining the motion to revoke, it is relevant to look at his performance while on probation, particularly when he is requesting to stay on it. And he's been on probation nearly 6 years, I think over 5.5 years, nearly 6 years. And that performance will be helpful in determining or mitigating if whether he stays on probation or if the court decides that he goes off of probation, and perhaps mitigating any potential sentence.
Okay,
And
I don't disagree. I don't disagree. So, again, though, I think the way to do it would be to make that request. I mean, and I don't know what conversations y'all have had, but make the request. I think coming at it aggressively might not be the way to do it. Sometimes you get more with honey than otherwise. So make the request to Mr. Nichols. If he says no, then let's go through what we need to go through. But let's try to do this amenably. The ducis tecum is not the way to do it unless it's set for a hearing. That's just the rules of evidence. And
Yes, Your
so
Honor.
that's not the way we're going to do
The
it.
ducis tecum was set for the day that it was initially set for a hearing, and it did specify that date for the hearing, I believe. And we ended up moving the hearing date because of conflict.
And Judge, I'd ask Ms. LeBeau to go ahead and get everything together.
Now the courtroom heats up. Jail logs, phone calls, appointment notes, drug tests, every part of his life pulled under the microscope. This isn't just a hearing anymore. It's an investigation into who he is, one record at a time.
There was something that the court was ordering her not to turn over.
I don't think on this list that there are, I mean, is there anything that y'all specifically had an issue with?
Ms. LeBeau, is there, or do you have any concerns you want
If there's,
to make the court aware of?
Your Honor, just with the clarification of our departmental chronologicals, which include anything that pertains to the case that happens, with chrono telephone calls, auto-generated appointments, reminders, office visits, drug tests, anything that we enter into the system. But those are the chronologicals through the probation office, as well as releasing of the jail logs, his sex offender verification, interlock reports, because those were not listed on the subpoena, as well as the offense report through DPS, which was released to me and my under a supervision officer. So just to clarify, as to those items specifically being released that were not listed, with the exception of the offense report.
Your Honor, we don't have to list those. We filed a 3914 discovery request. This was belt and suspenders because we didn't get any of the information relating to probation in our 3914 motion originally. I would also note that the chronologicals.
well, and these aren't, the reason you didn't get any of those is because those aren't his, they're theirs. And so they're not, I don't think Mr. Nichols has the ability legally to make probation give them those. I think once we talk it out, though, I think whatever Mr. Nichols, y'all get together, obviously offense report. If y'all have the offense report and you don't even have it, then you need to get, I mean, that's,
Right, I mean,
that's great. Everybody
it's all
can
stuff-
get the information in an amenable way. So let's do that. Y'all sit down. I want everything that you have that is, I don't know that there's anything I can think of that would be,
Unless, I mean, I guess
Not-
notes may be work product, but I'm not real.
that's what I'm thinking about, but it's
Not
not
too
really
concerned.
attorney's notes, and so I don't know that that would
I
be an
would object to
issue.
that, Your Honor, on the grounds that it's not attorney work product. It is merely work product of an employee, and it is discoverable and relevant to the case.
And that's what I just said. You seem very frustrated, and I'm not sure why. I don't know,
I'm confused why there's pushback at all on any request for a 3914 discovery when he's constitutionally.
Then tension. The judge sides with the defense but shuts down the attitude fast. You're being argumentative, even with me. Lesson 1 in court? Don't argue with the person holding the gavel. Respect goes further than defiance.
It should just be produced by probation without a fight. And we got a letter anticipatorily repudiating any production of discovery, and we had to file a motion to compel to that effect.
Well,
And that is alarming to me, that we would have to even compel anything under 3914.
this is not something that a lot of attorneys have done in our cases. And so if there is something, if you'll sit around and watch today how everybody gets along, hold on.
Yes,
And the
Your
last thing you want to do is talk over me.
Yes, Your Honor.
So I'm standing here, or sitting here saying that I agree with you, and you're still being argumentative, even towards me. And that's not going to get you anywhere. Hold on. Being argumentative with Mr. Nichols isn't going to help Mr. Sanchez. Being argumentative with these ladies isn't going to get you anywhere. I agree that you're entitled to this information. I just think there's a better, less argumentative, defensive way to do it. They were told to do what they were told to do because their understanding of the law is what it is. So I don't disagree that we needed to all get together, but it just needs to be taken down a notch. So I want the stuff turned over to Mr. Nichols, and then Mr. Nichols will turn it over as discovery. I'm not going to have probation start turning it over to the individual attorneys in cases, because I think the proper way to make sure it's in the portal, that everybody knows what the discovery is that they've received, so that it's electronic when you sign your any type of documentation, whether it's at a hearing or a plea or a trial of what you've discovered, that it goes through that portal so everybody knows what everybody's got. So y'all get it to Mr. Nichols. Mr. Nichols will put it in the portal, and then you will get it. Once you get that, if there's something that you think is not there, then contact us. We'll have a hearing if necessary. Contact Mr. Nichols. Hey, what about this? If it exists and he says no, then let's have a hearing about it. Okay? So y'all get that done, and then we'll reset the case for just an announcement in a couple weeks or so. Fine with that?
Yeah, that should be fine, Judge. We'll be able to get everything scanned in and provided through the portal.
Perfect, thank you. All right, y'all are all excused.
Evidence be needed?
I'm sorry? No, ma'am. If you'll just get what you need to Mr. Nichols, unless you are personally subpoenaed to be here for a hearing. Now, and on that date, we won't have a hearing on that date. So if we come in and there's pleas of not true, and we're going to have a hearing, we can come in on that date, enter pleas of not true or true to certain allegations. Then we would reset it for a court date. And at that point, if you need to be here, let her know. If you need a subpoena.
And that's the close. The judge orders a full reset. Follow the rules, get the evidence, and do it properly. No shortcuts. Because in court, timing and procedure aren't details. They're the difference between winning and losing.
If you just need us to let you know you need to be here, then we can do it informally. You just let us know, or let Mr. Franklin or Mr. Nichols know what your employer will require for you to be here for an actual hearing. Okay? Good?
Yes, Your Honor.
All right. Thank you, y'all.
Thank you.